married daughters to inherit land from their natal homes. But that legal right is nugatory if the people who you're going to live amongst do not consider it legitimate. So those are the issues that we deal with when we're talking about traditional justice. Now I'd like to call on Shem to make his presentation on the efficacy of alternative justice systems in rural areas. And I think that follows on what we've been talking about. Please put down the questions that you have for these presenters. We are going to have a point at which you can ask those questions. Shem, you have the floor. And you will not be treated as well as the commissioner, not because you're not commissioner.
Last time you say, when she sat down, you said that it's because she was speaking on this topic, which I'm also going to.
So let us hear you. Let us hear you.
All right. Thank you. So as you have heard, my name is Shem Oganga. Before I begin, allow me to invoke the words of the Holy Book in chapter 5 of Amos. The prophet writes, "But let justice roll on like a river, righteousness like a never-failing stream." So I stand here to speak for those who cannot speak for themselves because they've never seen that river. The rural resident swims in a different river, the alternative river, as we've put it. So my presentation today answers 5 questions. You know, when someone is only answering questions so that you will just listen. It's only 5 questions. Now, which is the alternative? You know, the word alternative means that alternative is a word that will just mean something that is rarely used, all right? So if 95% of the population uses the alternative justice system that we say because we are lawyers and jurists, then are we not the alternative? So we should think about that. So who are the actors of this system? We all know Article 159. So the actors are the mediators, negotiators, and all those. But most importantly, the elders. And I will not say these people are the part of the informal. Now for me, the informal are the chiefs and the policemen, and I will say the clergy. And then another question I have is, why is it that 95% are going for this system? So I found 2 answers. There are push factors, factors that push them out of the judicial system. So I'll only point out the important ones because we are all lawyers and we've spoken all these issues for long. I'll point those issues that have been rarely spoken about. The economic aspect. So I'll quote Professor Yashpal Gai in his book, Political Economy of Law. He says that the court system is tailored in a way that, okay, if we imagine the court system as a market, the judges are the sellers, and the customers are the citizens. And then the judges give goods. The goods they give are orders, injunctions, and all those kind of sorts. And then the clients or the customers are the citizens. And now, because it is a market, the most people who come to buy the goods are people from the cities and the towns. So the judiciary is tilted or tailored towards serving the needs of the people in the cities and the towns because they are the common customers. And the court does not bother itself to go further and expand its market because I think maybe it is because it is satisfied with the customers or the customer base. And then other issues are the bias, stigma that is towards the poor rural residents. The rural residents are mainly uneducated. They come to the court in dirty clothes. They don't know the language. And because of that reason, the judiciary or the actors in this court system, they look at them in a negative attitude. And at the end, because of this bias, they are always deemed guilty, dishonest. And we look at them as lazy people who are irresponsible. And because of that, they never get justice. So they are pushed out. And another issue is underfunding of the judiciary. You know, we talk this about austerity measures. These austerity measures have a ripple effect to the rural person. Because if you underfund the judiciary, the ripple effect is we'll employ austerity measures. We'll say we are not expanding, we are not building more courts, we are not employing more court officials, which means we will only retain our services within the cities and not go out to call upon or serve the rural resident. So, wonderful. And another thing is there are no incentives for the rural person to come to court. For example, our witness protection mechanism is not all right. So someone is taken to court, you are the witness, and then he's brought back out of bail, and then he comes to haunt you in the village. There's no policeman to protect you. So why do you have to go to court? Well, you know that he will go out of court on bail, and then he'll come for you. Then the pull factors. They are the factors that pull the people into the alternative justice systems. One, the courts are the creation of colonial masters. So we have this factor of cultural and social acceptability and appropriateness. Because the courts are the creation of colonial masters, in the village, we view them, or we view people who go to court as people who have betrayed us, all right? They are traitors, and we don't view them so well. And another thing is, if you look at the book of Luke chapter 12, verse 58, these are the words of Jesus. He said, when you have a conflict with your adversary, solve it quickly before he goes to court, because when he goes to court, he will go before the judge, and the judge will hand you to the prison in charge, and then the prison in charge will throw you to prison. So, you know, as the clergy and members of the church, we're always urged that solve your issues out of court. Don't go to court because, or I don't know, those are secular people. So most of the issues are mainly handled outside because of this, and the way the religious leaders encourage us, or they impose these words of Jesus that don't settle your matters to court, it's better you do it outside. But most importantly is the restorative aspect of the alternative justice system. Whenever you have a case, it is solved outside before the elders or the clergy. You are compensated. They are goats or any other form that you are compensated. And then the person who messed you up is either banished or rebuked, which rarely happens in the formal court system. Now, in a nutshell, I will go to the question 5, so which means that I'm winding up. Now, how do we enhance the alternative justice systems? My first point is that we should involve lawyers. And as I stand here, I believe I am an interventionist, and I believe law is a tool of social engineering. So we should involve lawyers. So alternative justice system is not a hostile takeover, but instead it is a system that has been propelled even through the Constitution to help in the delivery of justice. So there are ways that we should involve lawyers. One is through legal literacy, to teach special groups about their rights. For example, women, about their right to property and to inherit, and the children, their rights, and those people with special needs, the blind, the deaf, all this. It's only through legal literacy that we can bring them up. And another thing is the main reason why we should promote legal aid in alternative justice systems is because we want to promote constitutionality. We all know Article 159 and Article 10, those are our values. And so we want to uphold the rule of law, natural justice, and public policy. And this can only be done if we involve lawyers in social engineering, like the good commissioner has just said. For example, this issue of the inheritance of widows. And we have female genital mutilation. How do we deal with this? We can only deal with this if we involve the lawyers in social engineering. Our culture is not perfect. We don't want to colonize our culture, or are we imposing any values, but we are trying to remove the bad and remain with the good, which there are, right? And another thing, the Council of Legal Education to form an alternative justice system curriculum, which paralegals and lawyers will be trained on. So this curriculum should remove the technicalities and the legal mambo-jumbo that we have as lawyers, but instead should only have that law or language that tries to educate people about their rights and promotion of constitutionality and the rule of law and natural justice. And another thing is we need to recognize the role of post-colonial actors. So these people who came after the colonial system, like the chiefs. We need to look at the clergy. One, we need to accredit the clergy. It is my view that we need to, for example, the clergy can be an important tool in mediation, negotiation, and conciliation. And it is important that we teach them on the values and principles of mediation, conciliation, and negotiation, because they play a very important role. And then, if you're a common man, you'll understand the importance of having a paralegal in a police station. Because the common man, the most of things he does, when he has a case, he normally goes to the police station. It is his first center of reporting. And so the policemen, you find some of them don't know the law. This matter can be best handled as a civil matter, or this case, you don't have enough evidence. It is best we just bring that person here, we tell him, you've messed this guy up, let's clear this issue, instead of going to court, or kind of that stuff. So it is very important to have a paralegal in a police station. Every police station should have a paralegal. Now, another thing is we should pay the actors. We should pay the nyumba kumi and the elders. Because if you don't pay these actors, then they will use favors that they get, and then at the end, when we expect justice through the alternative justice system, we'll just find it is a monopoly. And then another thing is we should provide a policy to guide when conflicting customary laws collide. For example, remember the Wamboyo Etieno case. How do we go about that? So, I read the baseline, the judicial baseline policy. It does not deal with that. So we need to provide a clear policy. How do we deal with two customary laws which are conflicting? And then as I almost end, I'm going to a very important aspect. The elders. Let me honestly tell you, the Council of Elders we have, they are not the pure elders that we used to have in the pre-colonial times. The elders we now have, they're elders out of political influence. They are not the perfect elders that we had. So it is very important to come up with a mechanism of how these elders are appointed. We should accredit them and come up with ways for their removal. Not through laws, but through involving them. The former Chief Justice, Dr. Mutunga, was always organizing committee, and I think it was because of that his meetings with the elders, it is because of that the AJS policy baseline was formed by the Honorable Justice Ngugi. So, like for example, we recently had wrangles amongst the Luo Council of Elders. I don't know if you people have heard that. And then we normally have, like, in one community, we have various council of elders. And these council of elders arise almost towards the political seasons, like, 2022. Or we are the Kalenjin Council of Elders, and we are supporting Gideon Moi. And then we are the de facto Council of Elders, we are supporting Deputy President William Ruto. And then we are the Njuri Cheke, we support who was the former governor of Meru? Munya, we're supporting Munya. And then another will come that we are the jury checker, we are supporting Kiraitu Murungi. So these council of elders, at times, the way they are chosen should be questioned, and there should be clear and known mechanisms on how they come to be. And then as I wind up, we should define the jurisdiction of the alternative justice system. You know, when you read the AJS the baseline policy, it says that we should use the agency theory. And then Ngugi goes ahead and says that this agency theory, it is like we get all the powers through the citizen. And if he does not want his case to be tried in court and tried elsewhere, we should just let him be. And we should not put a demarcation on which case should be handled by the alternative justice system. But for me, I disagree. Because I believe one thing: if we want to uphold the rule of law, natural justice, uniformity in public policy and morality, then we have to put a demarcation. For example, sexual offenses should not be handled by the AJS. Another thing, like the case we have about murder, the murder case that was handled by the elders in Northeastern, by I think the Blue case, 2013, and other cases have preceded that. How is it that the court system allows someone who's been murdered, that the people to agree outside? I think this repudiates the foundation on which the state is based on. The main reason why the state was formed was to protect life, and that is the main reason. And if anyone takes away life, it should not be taken elsewhere. It should be handled by the court system and be charged appropriately. We should not use excuses that maybe witnesses were not there. It is because our witness protection mechanism is not proper, and our investigation are not proper. So we should not abdicate our duties to the alternative justice system and then just say, like, let us just be pedestrians and not interfere. But we should define the jurisdiction. For example, if you look at the laws, this policy is contradictory to the alternative dispute resolution bill that is in Senate. This bill, if you look at section 4, it says that the jurisdiction of the alternative dispute resolution should only be with certain civil cases, and not even election issues. So when we have an AJS baseline policy saying that we should not discriminate on whether it is a criminal offense or a civil issue, and we should not discriminate on whether it is a grievous matter or a little matter, a petty issue, then we should be careful on where we are going. And so, ladies and gentlemen, these are my issues, or the issues that are raised, that if we attend to, then our system, alternative justice system, will be effective, and then it will serve all citizens. But let us not forget that it is serving 95% of all the cases. So we, as the members of the judiciary or lawyers, should rise up and try to do more as we serve justice to the people. Thank you so much.
Thank you very much, Shem. And I can see you are a reader of the good book, and you have taken what Paul says to Timothy: do not let anyone look down upon you. You should be an approved workman who is not ashamed. So you were able to withstand my pressure that you are not keeping time. I think Shem raises a critical issue about, one, the autochthony of the councils of elders that are now coming up. Are they bona fide? Are they really the councils of elders? He also raises the issue of post-colonial structures, and I'd like us to think about whether chiefs and clergy are colonial or post-colonial. Because you see that's an issue. he talked about the common man, and I wondered about the common woman. There is a book that was written by jurists in Southern Africa looking at women's experiences with the legal process. And it's actually titled In the Shadow of the Law, because they really don't appear in the law. So maybe just think about if a man is invisibilized in the legal process, what happens to women, to children, and to others who are not man? And my last point is, you know, I have my favorite article of all times is The Man of Law. I'd urge you, if you can, read The Man of Law, because when we assume that man is privileged by law, the question is, are all men full men of law? All, and my assertion actually is that we are not all full men of law, because if you are a black man, that melanin in your skin detracts from your enjoyment of your rights. So racism comes in. That's what I'm saying. So in essence, let us always think about what are the experiences of those others, even when we are enjoying our rights. So I'd like us to have the last presentation for this session before we have tea. And please put down your questions. And this is by Samuel Moy. Samuel Moy is presenting on implementing mediation process as an efficient dispute resolution, for efficient dispute resolution in Kenya. Moy, you have the floor.
Okay, thank you. I'll start by referring to some of the presentations that have been done. And one of them was by Professor Wabwile. And he said, there is no reason for a parent to be served with a court order on maintenance of children. Then Morris talked about a situation where a widow has been able to acquire or has been able to get a judgment in favor of in-laws. And he was asking, how are you supposed to approach in-laws when you have won a case against them? Then I want to refer to a statement that was made by Professor Mbote, is that 90% of people in Kenya are not enjoying the services of the judiciary, and that has also been stated by Shem, that is the previous presenter. And I want to start with a case scenario. Actually, it's a case where I was involved in mediation. And it's a simple case of women at the village. And there were 6 women